wonder whether I could raise just a short point on timing. For administrative reasons, we would like to rise tomorrow at 3:45, losing a quarter of an hour of today's time. Is that going to cause problems, do you think, overall?
No.
Good. Well, we'll just do that and sit at normal times.
We have 3 days.
Yes.
I don't think either of us consider that we're going to need the whole of the 3rd day, but we probably will need a part of it.
Yes. Well, that's very reassuring.
Could you switch on your mics?
I'm grateful for the reminder. I recall hearing privileged conversations relayed into the restaurant on an earlier occasion.
Right. Well, I think there are other relevant circumstances.
We were at paragraph 55 of the Advocate General in Coditel. However, it's plain from the case law that the mere finding that private capital is not involved or permitted does not adequately satisfy in each case the TECAL criterion of similar control to that exercised over its own departments. It's plainly against this background that the questions to the referring court are to be interpreted. Now, if one moves on to 58, 2 basic criteria were therefore plainly decisive in determining the relevant questions in the Parking-Brixton case: the degree to which the concessionaire was market-oriented and the degree of its autonomy. These categories equate to those in the TECAL judgment, which in paragraph 51 also stated as a criterion the degree of independent decision-making capacity present or absent in the relevant body as compared with the public authority or authorities. Then I think one can move on from there to paragraph 66, where the Advocate General deals with the Asempo case, Spanish case. In contrast, the more recent judgment in Asempo shows that mere cooperation between municipalities is in general to be regarded as fulfilling the first TECAL criterion, similar control to that exercised over its own departments, without further analysis of the internal decision-making structures and majority shareholding relationships being called for. For while the wording reproduced above from the judgment in Cabo Termo was repeated in the later judgment in Asempo in paragraph 57, it was, however, slightly changed. The phrase in Cabo Termo, without being decisive, was replaced in Asempo by generally, thus tends to indicate without being decisive, tends to indicate generally. There are therefore many reasons for taking the view that where the awarding authority or concession awarding authority, either alone or in conjunction with other public authorities, owns the entire share capital in a body that is awarded a contract or concession, this as a rule shows that they exercise control over that body as over their own departments within the meaning of paragraph 50 of the judgment in TECAL. This rule can be displaced, but as demonstrated above, only by the concurrence of special circumstances. Then, moving on through this opinion, paragraph 71, however, the judgment in Asempo clarified that the size of the shareholding of an individual public body in a cooperative of public bodies no longer acts as the relevant yardstick as regards the possibility of control. The Court of Justice expressly stated that even a share in a cooperative as little as 0.25% of the capital of such a cooperative was held by the 4 autonomous regions, each of which held 1 share, does not prevent the tasks from being regarded as performed on a quasi-in-house basis as regards all the bodies which hold shares. Then I think one can move to paragraph 74. I don't believe I'm omitting anything of relevance to the analysis. 74, the deciding factor ought to be whether the participating public authorities have collectively control over the person in question, in this case the Brutele cooperative, or whether this cooperative acts separately from that collective control. And finally, paragraphs 77 and 78. It is a matter for the national courts, in this instance the referring court, to weigh up these matters in the specific case. Such an examination ought not, in this case, to produce a finding that any of the boundaries indicated above had been exceeded, for the internal decision-making structures of Brutele are characterized by the collective influence of the regional authorities participating by way of majority decision. They exercise their influence not only in the General Assembly, but also in the Governing Council, which is made up of representatives of the municipalities. Thus, the question of the power of control is already answered adequately and affirmatively. In addition, in relation to the subsectors, a preponderance of individual municipal decisions may in fact be discerned. Bruxelles' market orientation relates to tasks which are in the general interest, such as cable, television, telephone and internet, and does not suggest that any level that is neutral in procurement law terms was exceeded, notwithstanding the imprecision of the relevant criteria in this connection. Everything therefore points, in a case such as this, to cooperation between public bodies without any requirement for a tendering procedure. Now, at paragraphs 81 to 84, the Advocate General refers to the practicalities of the situation and the implications of taking a more restrictive rule for the freedom of public authorities to adopt efficient modes of organisation. Public procurement law is and remains one of the most influential policy instruments.
Sorry, paragraph what?
81.
81, thank you.
Public procurement law is and remains one of the most influential policy instruments of the member states and institutions of the EU in the process of European integration. This potential cannot, however, be used indiscriminately. Rather, its purpose must be brought into harmony with the values of other policy areas. If, as the referring court, Coditel and the Commission propose, one were to require the municipalities concerned to have comprehensive decision-making autonomy, in the sense that the relevant municipality exercises dominance over the relevant intermunicipal cooperative, then intermunicipal cooperation would in future be rendered virtually impossible. For it is an important feature of genuine cooperation that decisions are made as equals and that one of the partners in the cooperative does not dominate. It is therefore plain from the observations of Coditel and the Commission in the procedure and at the hearing that the yardsticks proposed by these two parties mean that it's a requirement that an individual regional authority must, as it were, be able to control a cooperative alone. It is obvious that such a case cannot in fact be regarded as cooperation or collaboration. As stated, that would render virtually impossible even pure intermunicipal cooperation. Intermunicipal cooperating regional authorities would then always have to reckon with the likelihood of having to award their tasks to private third parties, making more favourable bids. That would be tantamount to the compulsory privatisation by means of procurement law of public interest tasks. To construe the first TECAL criterion so narrowly would be to attach disproportionate weight to the competition law objectives, at the same time as interfering too much with the municipality's right to self-government and with it the competences of member states. Finally, 86 and 87, municipalities have themselves to decide whether they wish to carry out their general interest tasks with their own administrative, technical or other means without being compelled to have recourse to external establishments that do not form part of their own departments, or whether they wish to carry them out with the assistance of an establishment legally distinct from them in their capacity as public entity, awarding the contract or concession. If they opt for the second alternative, it is open to them to carry out these tasks of theirs on their own or in pure cooperation with other public authorities, controlled similarly to their own departments, and with the law on aid and procurement being largely suspended, or to tackle them by calling on private capital and or by increasing market orientation and participation in competition, the latter case entailing a loss of prerogatives. Finally, they have the further alternatives of the classic award to an independent third party or privatisation, which in any event do not confer any privilege in regard to competition law. To tackle the many traditional and new tasks of municipalities and local authorities in general is, particularly in times of restricted budgets, not always easy, especially for smaller authorities. In addition, many tasks, in particular in the areas of environment and transport, are not confined to the municipality. Conversely, intermunicipal cooperation without calling on private capital is, owing to its synergistic effects, a method used in many member states for performing public functions in an efficient and cost-effective manner. Now, the court itself held that the TECAL exception applied. At paragraphs 24 to 26 of the judgment, they deal with the non-application of the directive, this being a concession, paragraph 24, it's apparent from the referral decision that by becoming a member of Brutele, the municipality of Uccle entrusted it with the management of its cable television network. It is also apparent that Brutele's remuneration comes not from the municipality, but from payments made by users of the network. That method of remuneration is characteristic of a public service concession. Public service concession contracts do not fall within the scope of Council Directive 9250, relating to the coordination of procedures for the award of public service contracts, which was applicable at the material time. Notwithstanding the fact that such contracts fall outside the scope of that directive, the authorities concluding them are bound to comply with the fundamental rules of the EEC Treaty, the principles of equal treatment and non-discrimination on grounds of nationality, and the concomitant obligations of transparency. Without necessarily implying an obligation to launch an invitation to tender, that obligation of transparency requires the concession-granting authority to ensure, for the benefit of any potential concessionaire, a degree of advertising sufficient to enable the service concession to be opened up to competition and its impartiality to be reviewed. The application of the rules set out in Articles 12, 43 and 49, as well as of the general principles of which they are the specific expression, is precluded if the control exercised over the concessionaire by the concession-granting public authority is similar to that which the authority exercises over its own departments, and if at the same time that entity carries out the essential part of its activities with the controlling authority or authorities. So one has there a very clear statement that whether the directive applies or not, the TECAL exception does. Now, the application of the exception to the facts of Coditel itself is the next subject which the court considers, starting at paragraph 28. In order to determine whether a concession-granting public authority exercises a control similar to that which it exercises over its own departments, it is necessary to take account of all legislative provisions and relevant circumstances. It must follow from that examination that the concessionaire in question is subject to a control which enables the concession-granting public authority to influence that entity's decisions. It must be a case of a power of decisive influence over both strategic objectives and significant decisions of that entity. Of the relevant facts, which can be identified from the order for reference, it's appropriate to consider first the holding of capital by the concessionaire, secondly, the composition of its decision-making bodies, and thirdly, the extent of the powers conferred on its governing council. As regards the first of those facts, it should be borne in mind that where a private undertaking holds a share in the capital of a concessionaire, this precludes the possibility for a concession-granting public authority to exercise over that concessionaire a control similar to that which it exercises over its own departments, Stadthalle. On the other hand, the fact that the concession-granting public authority holds, alone or together with other public authorities, all of the share capital in a concessionaire, tends to indicate, generally, but not conclusively, that contracting authority exercises over that company a control similar to that which it exercises over its own departments. It is clear from the order for reference that in the case before the referring court, the concessionaire is an intermunicipal cooperative society whose members are municipalities and an intermunicipal association whose members in turn are solely municipalities, and it's not open to private members. Secondly, it's clear from the file that Brutele's governing council consists of representatives of the affiliated municipalities appointed by the General Assembly, which is itself composed of representatives of the affiliated municipalities. In accordance with Article 12 of the Law on Intermunicipal Cooperatives, the representatives at the General Assembly are appointed by the municipal council of each municipality from among the municipal councillors, the mayor and the alderman. The fact that Brutele's decision-making bodies are composed of representatives of public authorities which are affiliated to Brutele shows that those bodies are under the control of the public authorities, which are thus able to exert decisive influence over both Brutele's strategic objectives and significant decisions. Thirdly, it is evident from the file that Brutele's governing council enjoys the widest powers. In particular, it fixes the charges. It also has the power, but is under no obligation, to delegate to the sector or subsector boards the resolution of certain matters particular to those sectors or subsectors. The question arises as to whether Brutale has thus become market-oriented and gained a degree of independence which would render tenuous the control exercised by the public authorities affiliated to it. In this regard, it should be pointed out that Brutale does not take the form of a société par action or société anonyme, either of which is capable of pursuing objectives independently of its shareholders, but of an intermunicipal cooperative society governed by the law on intermunicipal cooperatives. Moreover, in accordance with Article 3 of the law, intermunicipal cooperatives are not to have a commercial character. It seems to be apparent from that law, which is supplemented by Brutale's statutes, that Brutale's object under its statutes is the pursuit of the municipal interest, that being the raison d'être of its creation, and that it does not pursue any interest which is distinct from that of the public authorities affiliated to it. Subject to verification of the facts by the referring court, it follows that despite the extent of the powers conferred on its governing council, Brutale does not enjoy a degree of independence sufficient to preclude the municipalities which are affiliated to it from exercising over it control similar to that exercised by their own department. So, pausing there, the summary of the reasoning is, if you have got an entity which is controlled entirely by local authorities, of which the members consist entirely of local authorities, you start with a presumption that the control test is satisfied, which is only to be displaced in special circumstances. Then, looking at this particular body, you acknowledge, or the court acknowledged in this case, that the governing council had wide discretionary powers of management, but they were only relevant, and I submit that this is the correct analysis of what is being said here, they were only relevant so far as that served to dilute the identification of Brutale with the relevant public function of the local authority. That's essentially the point being made in paragraph 38. Now, in those circumstances, the degree of independence which the governing body enjoyed, bearing in mind that the governing body consisted of representatives of the municipalities and was performing actions in the course of the performance of the municipality's public functions, was not objectionable. Now,
And the control in this case was exercised exactly how?
well, control was exercised by the governing council, on which no one municipality had a dominant voice. The ultimate authority is well, there are two organic bodies.
Yes.
There is the General Assembly, which is the body of shareholders, and there is the Governing Council, which is the equivalent of the Board of Directors.
Yes.
The Governing Council contains representatives nominated by the General Assembly, and the Governing Council has wide general powers of management, as summarised in paragraph 35, although more detail can be discovered in the account in the Advocate General's opinion.
Yes.
Essentially, what is being done here is that one is looking at the purpose for which the managerial discretions of the Governing Council exist, and asking oneself whether they are inconsistent with this effectively being a public-public partnership, to use the phrase used by a number of Advocates General. Now, the summary at paragraph 42 is accordingly that the Tekal exception applies to this particular arrangement. The court then went on to consider question 3, which was about collective control, which is also, of course, goes to the operation of the control test. By question 3, this is paragraph 43 at the top of 8503, by question 3, the National Court is essentially asking whether, where a public authority joins an intercommunal cooperative, of which all the members are public authorities, in order to transfer to that cooperative society the management of a public service, it is necessary, in order for the control which those members' authorities exercise over the cooperative to be regarded as similar to that which they exercise over their own departments, for that control to be exercised individually by each of those public authorities, or whether it can be exercised jointly by them, decisions being taken by a majority as the case may be. First, it should be pointed out that according to the case law of the court, Where several public authorities control a concessionaire, the condition relating to the essential part of that entity's activities may be met if account is taken of the activities which that entity carries out with those authorities. I'm pausing there. In other words, what's relevant is that Brutele dealt exclusively with the local authorities so far as concerned the services provided by the local authority. The fact that it also faced the public, to whom it let cable television facilities on commercial terms, does not mean to say that the function test is not satisfied. The function test looks exclusively at the relationship between the controlled entity and the public authorities and asks, do they carry out similar functions for other people? It's not, you don't have to carry, it doesn't matter that you also deal with the public at large when looking, so to speak, in the other direction.
I found that slightly difficult to pick up from the paragraphs you're looking from, the way you just put it.
I think that it is what is being said in paragraph 44. The condition relating to the essential part of that activities is met if account is taken of the activities which that entity carries out with all of those authorities.
Yeah.
In other words, you look and see what it's doing with the local authorities, and you ask, is it doing something similar for someone other than the local authorities? For example, suppose that Brutele also had an arrangement under which it supplied Sky Television to all of these people. Now that would involve a relationship between Brutele and Sky Television, which was analogous but not public to the relationship that it had with the public authorities. What this paragraph appears to be doing is excluding as irrelevant the commercial relationship that Brutele had when selling the cable service to the public living in these municipalities. It would be consistent with the reasoning underlying that case law to consider that the condition as to the control exercised by the public authorities may also be satisfied if account is taken of the control exercised jointly over the concessionaire by the controlling authorities. According to the case law, the control exercised over the concessionaire by a concession-granting public authority must be similar to that which the authority exercises over its own departments, but not identical in every respect. The control exercised over the concessionaire must be effective, but it is not essential that it be exercised individually. Secondly, where a number of public authorities elect to carry out their public service tasks by having recourse to a municipal concessionaire, it is usually not possible for one of those authorities, unless it has a majority interest in that entity, to exercise decisive control over the decisions of the latter. To require the control exercised by a public authority in such a case to be individual would have the effect of requiring a call for competition in the majority of cases where a public authority seeks to join a grouping composed of other public authorities, such as an intermunicipal cooperative society.
This is really the point the Advocate General was picking up, wasn't it?
Exactly so, yes.
Really.
Yes. Such a result, however, would not be consistent with community rules on public procurement and concession contracts. Indeed, a public authority has the possibility of performing the public interest tasks conferred on it by using its own administrative, technical and other resources without being obliged to call on outside entities not forming part of its own departments. That possibility for public authorities to use their own resources to perform the public interest tasks conferred on them may be exercised in cooperation with other public authorities. See ASEMFO. It must therefore be recognised that where a number of public authorities own a concessionaire to which they entrust the performance of one of their public service tasks, the control which those public authorities exercise over that entity may be exercised jointly. As regards collective decision-making bodies, the procedure which is used for adopting decisions, such as inter alia adoption by a majority, is of no importance. And I would interject there, or such as special resolution procedure requiring a 75% majority. That conclusion is not undermined by Konami. Admittedly, the court considered in that judgment that a 0.97% interest was so small as to preclude a municipality from exercising control over the concessionaire managing a public service. However, in that passage of the judgment, the court was not concerned with the question whether the control could be exercised jointly. Furthermore, in a later judgment, Asemfo, the court recognised that in certain circumstances the condition relating to the control exercised by the public authority could be satisfied where such an authority held only 0.25% of the capital in a public undertaking. Consequently, the answer to question 3 must be that where a public authority joins an intercommunal cooperative, of which all the members are public authorities, in order to transfer to that cooperative society the management of a public service, it is possible, in order for the control which those member authorities exercise over the cooperative to be regarded as similar to that which they exercise over their own departments, for it to be exercised jointly by those authorities, decision being taken by a majority, as the case may be.
I mean, that point seems to be made 25 times. I mean, what are you showing us? I mean, are you showing us to suggest that if your people did insurance for commercial bodies as well, that would be okay? It wouldn't worry anybody?
I don't, and if they did it for commercial bodies as well, I think they would fail the function test.
Quite, but I mean, I thought you said here that it didn't seem to matter that they were doing the same thing for other people.
My Lord, this is primarily concerned with the question whether, when no individual authority exercises control over a cooperative, but they can all exercise control over it collectively, that will satisfy the control test. Now, that is a proposition which my learned friend rejects root and branch, which is the reason why I am referring your lordship to this part of the case at some length.
Well, certainly they do say it a great number of times, rightly or wrongly.
Well, it's not that I'm saying it, my lord.
Well, is the point, I mean, we'll obviously hear from him in due course, but is his point that all of these cases, that they don't apply because they're not concerned with the directive?
That's his point.
That is his point.
That is his point. And my riposte to that is that since the court applies the same test in both cases, it's not a point of distinction. Indeed, there is one case, which I will refer to briefly in a moment, where the court actually said, we're not going to bother to decide whether it's the directive or the treaty that applies in this case, because the test is the same anyway. We'll just decide what whether the Tekal exception applies. Now, my lords, Commission and Germany is the penultimate case in this line, and the last of the really significant cases. That is a case that your lordships will find in volume 5 of the authorities volume, at flag 30. Now, this is an interesting case because it was a case in which the Tekal exception was in effect applied, although there was no control at all, either individual or collective, on the basis that the parties in question could have organised their affairs so that there was a collective vehicle. It therefore made no difference that actually they hadn't. The facts of the case were that the city of Hamburg proposed to contract with an operator to build and manage a very large waste incineration facility. There were 4 nearby local authorities, or Landkreise, contracted with the city of Hamburg to have the use of part of the capacity of that plant for their own waste treatment requirements. That contract enabled the city of Hamburg to order a much larger facility from the operator with corresponding efficiency gains for all 5 parties. No attempt, however, was made by the Landkreise in using the city of Hamburg for this purpose to put the contract out to tender, and on that ground the transaction was challenged by the European Commission. Now, plainly, the 4 Landkreise, which are essentially rural local authorities, had no control at all over the city of Hamburg, but the Tekal exception was nevertheless held to apply, and in very bold summary, the reason was that in a case where there was no private capital involved, the transaction would have come within the Tekal exception if the 5 public authorities had created a vehicle company and contracted with that. What they actually did, said the court, was just another way with exactly the same economic consequences in which a group of public authorities could cooperate in the use of their own resources. What seems clear from the reasoning in this case is that the essential features of the Tekal exception, the policy background of the Tekal exception, is one, the absence of a private commercial involvement, and two, the public interest of public authorities in being allowed to cooperate with each other in procurement, whether through a collectively controlled vehicle or not. Now, I won't trouble your lordships with the Advocate General. He took the view that in the absence of control over the city of Hamburg, the transaction was unlawful, and that was the view that was rejected by the court. If we may turn to the judgment, the issues between the parties are spelt out between paragraphs 17 and 24 of the judgment. The Federal Republic of Germany points out that the legal relationship is described in the preamble to the contract as a regional cooperation agreement for waste disposal. It paves the way for cooperation between the contracting parties who, if necessary, will assist each other in the performance of their legal obligation to dispose of waste and will therefore perform that service jointly in the region concerned. It is thus envisaged and in certain circumstances, that in certain circumstances the Landkreise concerned will agree to reduce for a specified period, the quantity of waste delivered in the event of the treatment facility malfunctioning. They thus agree to limit their right to performance of the contract. According to the Commission, the services provided in the present case cannot be regarded as administrative cooperation, insofar as the refuse disposal services do not carry out their activities under statute or other unilateral measures, but on the basis of contract. The Commission adds that the only permitted exception to the application of the directives on public procurement are those which are exhaustively and expressly mentioned therein, see Tekal. It submits that in the Commission and Spain, the Court confirmed that contracts for horizontal cooperation concluded by local authorities, such as that with which the present case concerns, are subject to the law on public procurement. The Federal Republic of Germany disputes that interpretation of the judgment in the Commission in Spain, taking the view that the case which gave rise to those proceedings, the Court did not expressly hold that all agreements concluded between administrative bodies fell within the scope of the public procurement law, but merely criticised the Kingdom of Spain for its general exclusion of agreements concluded between public bodies from the scope of that law. Secondly, the Commission does not accept that the Federal Republic of Germany can rely on the in-house exception, according to which contracts awarded by a contracting authority, where first the public body exercises over the other contracting party, which is a person legally distinct from that public body, control similar to that which it exercises over its own departments, and insofar as, secondly, that person carries out the essential part of its activities with the public body, do not fall within the scope of the public procurement directives. According to the Commission, the condition relating to the existence of such control is not fulfilled in the present case, since none of the contracting bodies concerned exercises any power over the management of the city of Hamburg. By contrast, the Federal Republic of Germany takes the view that in the context of the Hamburg metropolitan region, the requirement relating to the intensity of the control exercised which must be measured against the yardstick of public interest, is satisfied, since the authorities concerned exercise reciprocal control over each other. Any divergence from the objectives jointly defined would cause the cooperation to cease altogether. The principle of give and take implies that Hamburg and the Landkreise have an interest in maintaining that cooperation and complying with objectives jointly defined. On the basis of the judgment in Asemfo, the Kingdom of the Netherlands submits that the condition relating to the intensity of the control exercise may be fulfilled even if the control exercised by the public body concerned is more limited than that exercised over its own departments. It does not regard that condition as implying identical control, only similar control is required. In the Commission's opinion, that judgment does not constitute a relaxation of the case law resulting from Tekal. It finds only that the criterion relating to the intensity of the control exercised may also be satisfied where a specific legal framework establishes a relationship of dependency and subordination, allowing similar control to be exercised by several contracting authorities. That is not the situation in the present case. So that's how the battle lines were drawn. The reasoning on the essential point is to be found at paragraphs 34 to 38. However, the court's case law shows that a call for tenders is not mandatory where a public authority exercises over the separate entity and then they set out the Tekau test. Likewise, the court has held in respect of the delegation by a municipality of a public service to an intermunicipal cooperative, the object of which was exclusively to provide services to the affiliated municipalities, that could legally take place without a call for tenders, since it considered that notwithstanding the autonomous aspects of that cooperative's management by its board, the affiliated municipalities had to be regarded as together exercising control. See Coditel. However, it is undisputed in the present case that the four Landkreise concerned do not exercise any control which could be described as similar to that which they exercise over their own departments. Whether over the other contracting party, namely the city of Hamburg, or over the operator of the Rugenberger Dam waste incineration facility, which is a company whose capital consists in part of private funds. It must therefore be observed that the contract at issue establishes cooperation between local authorities with the aim of ensuring that a public task that they all have to perform, namely waste disposal, is carried out. That task relates to the implementation of Council Directive of 1975 on waste, which requires member states to draw up plans for waste management, providing in particular for appropriate measures to encourage rationalisation of the collection, sorting and treatment of waste. In addition, it's common ground that the contract between the city of Hamburg and the Landkreise concerned must be analysed as the culmination of a process of intermunicipal cooperation between the parties thereto, and that it contains requirements to ensure that the task of waste disposal is carried out. The purpose of that contract is to enable the city of Hamburg to build and operate a waste treatment facility under the most favourable economic conditions, owing to the waste contributions from the neighbouring Landkreise, making it possible for a capacity of 320,000 tonnes per annum to be attained. For that reason, the construction of that facility was decided upon and undertaken only after the four Landkreise concerned had agreed to use the facility and entered into the commitments in question.
I'm a bit lost here. As between Hamburg and the Rugenberger Dam people who are apparently the operator, the builder or whoever,
Yes.
Presumably the procurement directive would apply, would it?
One assumes so because, there was a substantial private involvement.
Quite. So it's only as between the little group of local authorities, the Landkreise, and
Exactly.
Hamburg, that this point arises.
Indeed. Over the page, at paragraph 44, there is an analysis of the relevant features of the contract and a conclusion, 44 to 47. It thus appears that the contract in question forms both the basis and the legal framework for the future construction and operation of a facility intended to perform a public service, namely the thermal incineration of waste. That contract was concluded solely by public authorities without the participation of any private party, and does not provide for or prejudice the award of any contracts that may be necessary in respect of the construction and operation of the waste treatment facility. The Court has pointed out in particular that a public authority has the possibility of performing the public interest tasks conferred upon it by using its own resources without being obliged to call on outside entities not forming part of its own departments, and that it may do so in cooperation with other public authorities. The Commission stated at the hearing, moreover, that had the cooperation at issue here taken place by means of the creation of a body governed by public law, to which the various local authorities concerned entrusted performance of the task in the public interest of waste disposal, it would have accepted that the use of the facility by the Landkreise concerned did not fall under the rules on public procurement. It takes the view, however, that in the absence of such a body for intermunicipal cooperation, a call for tenders should have been issued for the service contract concluded between the Stadtreinigung Hamburg and the Landkreise concerned. It must be observed, though, that the community law does not require public authorities to use any particular legal form in order to carry out jointly their public service tasks. Secondly, such cooperation between public authorities does not undermine the principal objective of the community rules on public procurement, that is, the free movement of services and opening up of undistorted competition in all the member states, where implementation of that cooperation is governed solely by considerations and requirements relating to the pursuit of objectives in the public interest, and the principle of equal treatment of persons concerned, referred to in the directive, is respected, so that no private undertaking is placed in a position of disadvantage vis-à-vis competitors.
I wasn't sure that I picked that up from Stat Harrow.
I'm sorry, my lord.
I wasn't sure I picked that up from Stat Harrow, paragraph 50.
No, what
quite
your lordship
those
would have
terms.
picked up from Stat Harrow is the first glimmering of a concept of the public interest,
Yes.
which is most fully stated in this case.
Right. So this is an expansion, really, of the
Indeed
concept.
it is. I mean, all that Stat Harrow said
Yes.
was that because the 25% private shareholding diluted the concern that the entity would have with the public interests, it failed the control test and would have failed it even with a smaller proportionate share. What is happening is that's from that small beginning, this notion that actually what the control test is about is ensuring that there is a sufficient identification of the supplier with the public functions of the contracting local authorities. That is really what this is concerned with. It's ensuring that the public function of a local authority is not so far diluted that it is effectively engaging in a market-oriented exercise in which other market participants ought to be allowed to participate. Lords, the final citation is, on this point, is Sea and the Comune di Ponte Nossa, which I can take very briefly because it is essentially another example. There's one reason why I want to ask your lordships to look at it. Your lordships would take the supplemental authorities bundle.
Is this after the Court of Appeal's judgment on
This is...
I thought Commission
I
in
think it
Germany
may
was the
be,
same
yes.
day as the Court of Appeal.
I thought it predated.
the Commission in Germany was the same day as the Court of Appeal.
That's what I said.
Sorry, I thought you were referring to the Sea case. Yes, it is.
Right, so they didn't take
The
account.
Sea case is after the Court
Yes.
of Appeal and was not taken into
But
account.
Germany was?
No, because
No.
the Germany case was decided on the very
That's right.
same day by
Yes,
coincidence. And the other case which missed the boat, so to speak, is Codital, which came between Mr. Justice Burnton's or Lord Justice Burnton's decision at first instance and that of the Court of Appeal.
So,
Now,
So where's ours in the new bundle?
in the new bundle, your lordships will find at flag 4
So
the decision in Sea.
say,
This was about a contract for the collection and disposal of waste between the commune of Ponte Nossa and a consortium company owned by a number of municipalities, the majority shareholder, in fact, being a different commune. So it depended on the collective control point. There was an issue in this case about whether it was a service concession governed by the treaty directly or a contract for services governed by the directive. But the issue by now matters so little that the Court of Justice declined to decide it, simply pointing out that the test for applying the TECAL exception was the same, so that it didn't matter which category it came into. And that will be found between paragraphs 35 and 41 of the judgment of the Court. On any view, whether the case in the main proceedings concerns a service concession or a public service contract, and whether or not in the latter case such a service contract falls within the ambit of the directive, are matters that do not influence the reply to be given by the Court of Justice to the question referred for a preliminary ruling.
yes.
And they then go on to apply TECAL as applying indifferently in either case. I won't read it because it is repetitive of reasoning that your lordships have already seen, but between paragraphs 53 and 60, your lordships will find a reiteration of the principle that collective control is enough to satisfy the control test, a reiteration which is clearly heavily dependent on coditel. My Lords, having dealt with the main material, what I would like to do is to turn to the 5 issues listed in my learned friend's printed case in turn, and to deal with the points of principle that arise. The first of them is whether the Tekal principle forms part of the English regulations at all. Now, in our submission, the Tekal exception is a limitation on the scope of the public procurement regime, which is implied from its underlying purpose. At the time when the current directive was issued in 2004, it was a well-established incident of the EU public procurement law. The regulations were made to implement the directive of 2004. Indeed, the whole basis of the English law on public procurement now is the European Treaty and the directives. It's the only reason why we have any legislation on the subject. There was a period between 1980 and 2000 when there was legislation which required even more extensive putting out of contracts to tender by local authorities under domestic law, quite independently of European law, but that is not the case now. When the draftsman of the English regulations transposed this directive into English law, we submit that he must be taken to have intended to transpose it together with the accumulated body of judicial exposition of the concepts that were being transposed, unless, of course, he says otherwise. That, in a nutshell, is our submission. Now, the contrary argument, which my learned friend puts forward with great elaboration in his printed case, boils down to this, and I believe I'm fairly summarizing it, namely that the exclusion of quasi-in-house contracts from the scope of the directive cannot be achieved as a matter of construction, according to English rules of construction, which of course apply to the regulations. The regulations, he says, apply to contracts, and a quasi-in-house contract is a contract, and indeed a contract for consideration. So the argument is that once you have adopted the concept of a contract for consideration as the defining category for what is within the regulations, it is no longer possible to exclude any category of transaction which constitutes a contract as a matter of English law, unless you do it expressly, which is what the draftsman did for service concessions. Now, my lords, that argument, if accepted, would lead to a significant difference between English procurement law on the one hand and on the other both EU law and the national laws of other European countries, as we've seen reflected in the European cases. In our submission, it is wrong. And I'm going to make, if I may, a number of related but distinct points about that. First of all, the absence of any reference to the Tekal exception in the language of the regulations is, in our submission, no more significant than the absence of any mention of it in the directive which is being transposed. The draftsman of the regulations has relatively woodenly transposed the thing with all its omissions and additions from one instrument to the other. In each case, the Tekal exception is an implication derived from the limitations of the EU procurement regime.
It presumably could have said something about this if the draftsman had wanted to, could it? Or was it something to inhibit doing that?
It could, although it would have run the risk of, as a matter of drafting, if it had incorporated the two Tekal conditions in the language there, it would have run the risk of, so to speak, freezing them in English law, when actually one can see that they are much more subtle in their application under EU law. So if the draftsman had applied his mind to the possibility, I expect that he would have been deterred from it. The reason, of course, why the draftsman did incorporate the exception from the for service concessions was that the directive did. The directive had an express exception of service concessions, so the draftsman duly includes one in the regulations.
Could you give chapter and verse for that?
Yes, Article 17 of the directive excludes service concessions, and Article 6 of the regulations excludes them in 6.2m, I think it is. Now, secondly, the meaning of a contract for pecuniary interest.
Sorry, can you say that again? Secondly, what?
The meaning of a contract for pecuniary interest, the expression used in the directive, is itself a question of European law in the context of the directive. Your lordships will find that stated probably most conveniently in a single paragraph of a case which your lordships can find in volume 4 of the bound volumes of authorities at flag 24. The case is Asociación de Empresas de Reparto, which is about the contracts for the delivery of mail in Spain, but I think the statement of principle is self-contained and can be found in paragraph 50 of the court's judgment. In this respect, it must be noted that the definition of a public service contract is a matter of community law, with the result that the classification of the cooperation agreement under Spanish law is irrelevant for the purposes of determining whether it falls within the scope of the directive. And that must perhaps be obvious from the fact that any expression used in a directive is to be construed in accordance with EU law. Now, the expression contract for pecuniary interest has been defined by the court as meaning simply a contract for consideration moving from a public authority. I think my learned friend submits that there may be a difference between a contract for pecuniary interest and a contract for consideration in the regulations, but its meaning in the context of the directive is reasonably clear from a case which your lordships will find at volume 6 of the authorities volume, flag 39, which again is a case where a single self-contained statement of principle is all the citation that is required. This case is the actual title to it is not easy to discover from the extract you've got.
I think we've got the index.
You'll find it in the index.
It's Milan.
That's right. It's the Milan Order of Architects against the Commune of Milan, and it's about the distribution of architects' retainers.
Yes.
Paragraph 77. It must be pointed out that the pecuniary nature of the contract relates to the consideration due from the public authority concerned in return for the execution of the works which are the object of the contract referred to in Article 1A of the directive and will be at the disposal of the public authority. So effectively, a contract for pecuniary interest is a contract for consideration moving from the public authority. Now, in TECAL itself, the exception, which TECAL is authority for, was expressed as a limitation on the meaning of the term contract in writing for pecuniary interest. But that was not, as I sought to show your lordships this morning, because of any analysis of the meaning of the language contract in writing for pecuniary interest. It was simply because of the underlying policy, which is why it also applies to the treaty. And paragraph 49
of
TECAL, if your
Yes.
lordships would find it convenient to go back to it. It's in bundle 7, tab 46.
yes.
Paragraph 49 of TECAL is, taken together with paragraph 50, is not saying that a contract with a distinct legal entity is not a contract at all if the entity is controlled by the public authority, or if there's no pecuniary interest in such a case. That would be an absurd statement. What paragraphs 49 and 50 are saying is normally you only need to show that there is something which counts as a contract in domestic law, i.e. an agreement between two distinct persons. However, something may be a contract under the relevant domestic law, and yet not a relevant contract for the purposes of the EU procurement regime. That's essentially what is being said in 49 and 50 of TECAL. Now, when one turns from the directive to the regulations, of course, have to be construed in accordance with English law, but even an English lawyer is entitled to say that given the background and purpose of the regulations, the expression contract for consideration must have been intended to reproduce the effect of the expression in the directive, contract for pecuniary interest. Now, it is perfectly true, as I've pointed out, that the draftsman of the regulations has gone to the trouble of expressly excluding service concessions, but as I said, he has simply done that because that was what the draftsman of the directive did. In fact, the directive which he is transposing did not expressly exclude quasi-in-house contracts. TECAL isn't expressly there. But nobody is suggesting that the omission of an express TECAL exception from the 2004 directive has abrogated the TECAL exception as a matter of EU law. Why should a drafting approach, which has simply been taken woodenly from the original directive into English law, have the effect of excluding it there? My lords, thirdly, it is not correct as a matter of English law, although English law is somewhat more restricted in the nature of the things that it can take into account in construing legal instruments than EU law is, it isn't correct as a matter of English law that the scope of a statute or a statutory instrument depends exclusively upon its language. Even where the language used is absolute, its scope may be limited by reference to its context, its subject matter, and its purpose, just as it can be in European law, although possibly in a less muscular fashion. The best known of many English judicial statements to this effect is probably the well-known statement of Lord Diplock in Camin's Ballroom. It's perhaps so appropriate in this context that I will invite your lordships to look at it. It's in the third flag of the Supplementary Authorities bundle. Camin's Ballroom was about the Landlord and Tenant Act 1954, which provided in section 29 that no application to a court for a new tenancy could be entertained unless it was made at least 2 months after the new tenancy had been requested of the landlord. And although couched in absolute terms, that was said not to be absolute in its effect. The details of the reasons for that don't matter, but the general approach to construction is what I'm relying on this for. If your lordships turn to page 879 at the beginning of Lord Diplock's speech. My lords, the closely balanced division of opinion in your lordship's house and in the Court of Appeal about the effect of section 29 reflects once more competing approaches to the task of statutory construction, the literal and the purposive approach. The words to be construed are no application under subsection 1 of section 24 shall be entertained unless it's made not less than 2 months nor more than 4 months after the giving of the landlord's notice under section 25, or as the case may be after the making of the tenant's request for a new tenancy. Upon a literal approach, semantics and the rules of syntax alone could never justify the conclusion that the words no application shall be entertained unless mean that some applications should be entertained notwithstanding that neither of the conditions which follow the word unless was fulfilled. It is not the meaning of entertained that makes this conclusion possible. It would be equally impossible whatever verb in the passive voice was substituted. It can be justified only upon the assumption that the draftsman of the Act omitted to state in any words he used in the subsection an exception to the absolute prohibition to which Parliament must have intended it to be subject. A conclusion that an exception was intended by Parliament and that exception, what that exception was, can only be reached by using the purposive approach. This means asking the question, what is the subject matter of Part 2 of the Landlord and Tenant Act? What object in relation to that subject matter did Parliament intend to achieve? What part in the achievement of that object was intended to be played by Section 29(3)? Would it be inconsistent with the achievement of that object if the prohibition were absolute? If so, what exception to or qualification of the prohibition is needed to make it consistent with that object? And then he then applies that approach to the construction of the 1954 Act. Now, my lords, the courts are particularly inclined to depart from the literal meaning of general words in a statute, so as to limit them to the particular context and purpose of an enactment. Can a minister do something by virtue of a power conferred in general terms in an act which is completely outside the purpose for which and the context in which the act appears to have been passed? Generally, the answer to that question is no, not by virtue of a linguistic analysis of the words, which are generally wide enough, but by virtue of its purpose. Do general words in a statute have retrospective application? Or do they have penal consequences? Generally, they do not. Not because the words are insufficient in themselves, but because the presumption is that that cannot have been intended unless the legislator said so. My lords, the fourth observation which I should make on this point is that the exclusion of the quasi-in-house contracts from the scope of the EU procurement regime is clearly not a technicality or an accident or an oversight of drafting. It is a considered policy of European law. It is quite plain from the reasoning of the European Court that it is thought undesirable to require public authorities to open up their procurement to competition when they are able and willing to obtain the relevant goods or services from their own resources or from a controlled entity. That point is made in several of the European cases that I have cited, but perhaps most forcibly in Coditel at paragraphs 47 and 48. Your lordships have just seen it, we needn't go back to it, which itself reflects the observations of the Advocate General in that case. Exactly the same point was made in Stadthalle, paragraph 48, your lordships have seen that, and in Commission and Germany at paragraph 45. Indeed, it's also made in quite forceful terms by Advocate General Kokott in her opinion in Parking Brixen, paragraphs 70 and 71. Now, it is therefore clearly a considered balance at which European law has arrived. Now, I am not submitting that this is a mar-leasing case, because it's not a case in which the United Kingdom would have been in breach of its obligations under EU law by failing to transpose the TECAL exceptions into the regulations. The reason why I accept that is, if one asks oneself hypothetically, could Parliament have passed legislation imposing obligations of transparency and non-discrimination and all the detailed procedural rules in the directive, not just in cases where EU law required it, but in other cases where it didn't? The answer would surely be yes. Parliament could have said, we will impose the detailed rules on concessions as well. It could have required local authorities to expose even their in-house direct works departments to commercial competition and indeed for a period of 20 years at the end of the 20th century, it did exactly that. So we accept that a leasing point doesn't arise. But if the legislature was going to impose on public authorities in the United Kingdom obligations which it was not required to impose upon them by European law, then one would, I suggest, expect them to do it on purpose and expressly. One would not expect them to do it in an implementing regulation and as the accidental result of using the English legal term which corresponds to contracts for pecuniary interest, namely contract for consideration.
This is a new point, is it? Nobody's ever quite said this in those terms.
Well,
in
Lord,
the context of EU law.
It's only...
I know you say there's a sort of general flavour of how one interprets statutes, but if one comes down to the specifics of how one draws out from European Union law principle, which has not been expressly mentioned, that is a new point.
My Lord, it's a new point in that particular context, but of course it is only a specific illustration of a more general principle that in construing statutes, and even more so perhaps in construing statutory instruments, the courts have regard to the juridical background against which they were passed. When a statutory instrument is made for the specific purpose of implementing an EU regulation, the contents of the EU regulation and its effect are a matter of relevant background of overwhelming importance. I'm not going to suggest that the degree of muscularity in distorting language, which is justified by the leasing approach, is justified in a case where the leasing approach does apply. However, in our submission, it is perfectly legitimate to read general words as subject to a restriction to be implied from the subject matter and legal context and purpose of an enactment. And when the subject matter, context and legal purpose of the enactment are derived from a proposition of EU law, which on the face of it is sought to implement, in our submission, that is a perfectly relevant approach to construction, which involves no degree of muscularity at all.
We don't get any help from the explanatory memo?
From?
The explanatory memorandum?
Well, what you get from the explanatory memorandum, among other things, is that it undoubtedly was the view of the draftsman that he was transposing the directive, and he went to the trouble of saying in what respects he was not confining himself to transposing the directive, because the explanatory memorandum does make the point that it is taking on board the decisions about the period of time that has to elapse between the making and implementation of a public procurement contract. He makes the point that isn't in the directive. It's arisen from more recent decisions of the European Court. So what we do get from the explanatory memorandum is that it was believed to transpose European law as set out in the directive directly into English law. But the essential point is that the subject matter of these regulations is obligations imposed on public authorities by EEC law, and their purpose is to implement EEC law. Now, my lords, the fifth observation which I would make, directed to the same point, is that the directive is, among other things, a harmonisation measure. The power to make this directive is expressly derived not just from Articles 43 and 49, but also from Article 95, which is the power to approximate the laws of member states with a view to the establishment and functioning of the internal market. Recital 2, if your lordships would take the first bound authorities volume, records that its object is, among other things, to coordinate the laws of member states. About halfway down, your lordships read this morning, but about halfway through recital 2. However, for public contracts above a certain value, it is advisable to draw up provisions of community coordination of national procedures for the award of such contracts which are based on these principles, so as to ensure the effects of them and to guarantee the opening up of public procurement to competition. Now, that statement is capable of being read as simply referring to the coordination of the detailed rules as opposed to the underlying principles. On the other hand, if the United Kingdom decides, or if the English courts decide, that the detailed rules apply in circumstances where in other member states they don't apply, it is hard to see that the objective of coordinating member states' laws as regards the procedures that have got to be applied will have been achieved. Now, in my submission...
Sorry, can I just... you used the word harmonisation a moment or two ago.
Yes, sorry, approximation
It
is the
doesn't really...
correct term.
It's approximation.
Yes.
Yeah.
Now, in our submission, it would be distinctive...
Does any other recital, besides 2 deal with, because as you point out, I mean, there's reference to 95 in the title. Does any other besides 2 deal with approximation?
My Lord, no. The rest of the recitals deal almost exclusively with... They're very long, and I therefore... They deal generally with the policies underlying particular rules, particularly in those respects which have changed since 1992.
Right. But I mean, therefore, to coordinate national procedures would seem likely, therefore, you would suggest to reflect the reference to 95 in the title.
Indeed. I can't see that there is anything else. Now, my Lords, in our submission, it would be very odd if a significant and policy-based exception to the public procurement regime of the European Community were to apply in some member states but not others. Now, I accept that it would be open to a member state, to the United Kingdom, for example, to legislate for categories of transaction not covered by the EU procurement regime, but one should not, in my submission, readily conclude that they have done without some express indication that that was what was intended. My Lord, the 6th point that one needs to bear in mind in considering all of these earlier points is that the point that I've already made, that the TECAL exception applies equally to procurement obligations arising from the directive and to those that arise directly from the treaty in cases where the directive doesn't apply. Now, your Lordships can draw 2 relevant conclusions from that. One is that the TECAL exception does not depend on the mere use in the directive of the concept of a contract for pecuniary interest. Therefore, it is difficult to say that it has been excluded simply because of the manner in which that phrase has been transposed into English law. It's clearly much more fundamental than any particular turn of phrase. Well, the reality is that none of the relevant provisions of the treaty refer to contracts or to pecuniary interests. The treaty provisions can apply in cases where the directive and its language are wholly inapplicable, and they can apply to cases where there's no contract at all, as in a SEMFO. Now, what that suggests, I would suggest, is that arguments based on the contractual language of the directive and the regulations, and arguments based on the fact that a quasi-in-house contract is unquestionably a contract in English law, are not really getting at the true basis on which the TECAL exception applies. It's not dependent on the notion of a contract. What the EEC has said, what the ECJ has said, is that because as a matter of policy this is excluded, it is outside the category of contracts for pecuniary interest, which is the category governed by the directive. But that is not a linguistic argument so as to make it legitimate to say that the reference to the contractual language of the directive is conclusive in the regulation.
So I'm being a bit slow here, but I mean, what happens with a transaction, an arrangement outside the directive, but covered by the treaty in the UK? The regulations don't apply, is that right?
Yes.
So what applies? We just directly apply EU law?
You directly apply Articles 43 and 49 of the treaty.
Which then automatically would import the exception.
Yes, it would.
So you would be treating on a completely different basis these particular arrangements that chance not to fall directly under the directive.
Indeed you would, and that is the second point that I was going to invite your lordships to draw from this, which is that, and this is a consequence that was actually referred to by the Advocate General in one of the cases I showed your lordships this morning. I think that it was the Asemfo case, but I'd better just check that, where he described it as absolutely absurd, because the point that was made, the point that I make, is if your lordships accept my learned friend's argument, that would mean that the regulations were not subject to the TECAL exception, but the corresponding obligations under Articles 43 and 49 were subject to it, which is the point that my Lord Brown has made. That would mean, for example, that contracts below the value thresholds would be subject to more exacting obligations on public authorities than contracts above the value thresholds, because the contracts above the value thresholds would have no TECAL exception, but the contracts below the value thresholds would have a TECAL exception. Now, the imposition of more onerous obligations below the threshold than above it is the exact reverse of what seems to have been intended in inserting the value thresholds in the first place. It would mean, for instance, to take another...
the other way around, isn't it?
Above the threshold, the directive applies, there's no TECAL exception, if my learned friend is right.
You always have to go out, yes?
So therefore it's more exactly.
Yes.
That is more... sorry, perhaps I have got this wrong. Can you find a little bit in the Advocate General? It's in what? I think, I'm not sure. Yes, sorry, it isn't as... Your Lordship is quite right to pick me up on that. I've got my logic wrong. But it is nevertheless, I would suggest, a very odd state of affairs when you have some transactions which are subject to the TECAL exception and others that are not, in circumstances where the only difference between those transactions relates, for example, to the value, the operation of the value threshold. Your Lordship is quite right to pick me up about my having got a more onerous thing the wrong way round. But in our submission, it would introduce an element of incoherence into the application of EU law if the English courts were to say that the TECAL exception had no application in directive cases, but did apply undamaged in other cases.
Mr. Sumption, you use the phrase TECAL exception, and it's obviously good shorthand and so on, but is it what's an exception from? I mean, looking at the way that they approached in the Commission against Germany and so on, it's more as though they're saying, well, the whole policy behind the procurement directive and the treaty and so on, it doesn't apply to this situation at all. It just is never intended to hit this kind of thing at all. It's not really an exception. It's just that it doesn't apply to it. It doesn't.
My Lord, that is absolutely right. It is effectively drawing the limits of the policy in a place where this lies outside it, so there's nothing to accept it from. I entirely agree with that. But there is one reservation I have to make, which is that there is plenty of authority, some of which your lordships have seen this morning, to say that it has got to be approached as if it were an exception.
Narrowly.
In other words, narrowly. I can't submit that your lordships are entitled to treat this in an entirely neutral fashion. You have to treat it as a derogation because that is the way that it has been described in successive cases.
Yes.
Just following on from what Lord Roger said, so far as one is looking at fine verbal points, now I understand that you're not, but you've concentrated on the definition in the directive contracts for pecuniary interest.
Yes.
But that definition also requires there to be, on one side of the transaction only, an economic operator.
Yes.
And if one chases that through, there is a definition that an economic operator covers the concepts of contractor, supplier and service provider. It's used merely in the interest of simplification. But if you then chase up contractor, supplier and service provider, they are required to be entities which offer something on the market. And that, it seems to me, is at least the beginning of a doubt as to whether the quasi in-house provider is on the market in the relevant sense.
Yes. Well, that is effectively getting at the same point as at least the function test.
I mean, have Luxembourg ever realised that?
They have not referred to that as part of their reasoning, either in the opinions of the Advocate General or in the reasoning of the court, not in any case that I have read, at any rate. There are so many of them that I'm reluctant to give your lordship a guarantee it isn't to be found somewhere.
Because, in fact, in the regulations, economic operator comes out just as person.
Yes, that is true.
That's the effect of Regulation 4, is it?
I mean, the reason for having a broad definition of economic operator in the directive has got to apply to different kinds of contract. I've been using the shorthand supplier because it seems appropriate in the context of services. But the definitions often have to cater for more than one type of contract.
Yes, services provider as a person and contractor as a person.
Yes. Well, a legal person.
Who offers something on the market.
In the market, yeah.
So, I mean, it's possible that the draftsman thought he didn't need to do anything about all this because he's already encompassed this exception in his definition.
The draftsman of the directive?
No, of the regulation.
Well, my lord, that is possible.
But a little unlikely, maybe.
My lord, of course, one speaks of draftsmen in the impersonal fashion one does. The reality is that what draftsmen do in these cases is that they go through the directive and they iron out terminological points which are not going to make much sense to an English lawyer and produce as close a translation as they can. There isn't as much cogitation behind it as perhaps there ought to be. My lords, the seventh and last observation which I want to make on this subject concerns the statutory power to do this. The regulations, as your lordships have seen, were made under Section 2.2 of the European Communities Act. That act will be found in the first Bound Authorities volume. And its terms are very familiar. It's Section 2.2, page 3 of 9.
Sorry, tab what?
I'm sorry, what? Volume 1, tab 6.
Tab 6, yes, I'm sorry, that was all that was missing, yeah.
Section 2.2.
Yes. Subject to Schedule 2 of this Act, Her Majesty may, by order in Council, and any designated minister or department, may make provision A for the purpose of implementing any community obligation of the United Kingdom, or enabling any such obligation to be implemented, or of enabling any rights enjoyed or to be enjoyed by the United Kingdom under or by virtue of the treaties to be exercised, or B, for the purpose of dealing with matters arising out of or related to any such obligation or right, or the coming into force or the operation from time to time of subsection 1 above. Now, I'm not going to take your lordships to authorities on that provision like Oakley, because I accept straight away that the power to make regulations is conferred in very wide terms, and in particular, subsection 2b, for the purpose of dealing with matters arising out of or related to any such obligation or rights, or the coming into force, the operation from time to time of subsection 1 above. Those are particularly wide words. The power, therefore, is not confined to doing the minimum necessary to comply with a community obligation of the United Kingdom, but even, I would suggest, under B, there has got to be a relevant connection with the EEC legislation which is being implemented. It has got to arise out of or be related to a community obligation. Now, this is not a case where the directive confers an option on the United Kingdom to derogate from some part of it, or legislates for different ways of achieving the same object. There are various respects in which the directive produces optional solutions, and the United Kingdom can choose which one it likes and can embody whichever one it wishes in the implementing regulation under that power. But the problem is that if the TECAL exception does not apply to the regulations, it must follow that the draftsman must be taken to have intended to apply the onerous obligations of the EU procurement regime to a class of transactions which lies completely outside that regime. Whether based on the treaty or the directive doesn't matter for this purpose. Now, the only connection that that exercise would have with the implementation of a community obligation of the United Kingdom is that the subject matter would be the same, namely public procurement. Now, in our submission, simply to say that the subject matter is the same, therefore, while we are about the process of implementing the directive, let us do some other things to tidy up English law on the same area, is not a permissible use of this particular power. If one can think of a few examples, would it be open to the Treasury under this power to impose a raft of additional obligations on public authorities which were not to be found either in the treaty or in the directive? Would it be permissible for the United Kingdom under section 2.2 to say, we are going to implement the regulations without reference to the value thresholds at all? We're going to say everything of whatever value is covered. Now, that would not be something it was required to do by the directive. Could the Treasury say, well, it would be tidier not to have this distinction. We will impose this obligation on all of these transactions which aren't actually covered by the directive at all. In our submission, that would not be something related to the implementation of the directive. As I have mentioned in other contexts, between 1980 and 2000, local authorities in the United Kingdom were subject to what was called the compulsory competitive tendering regime. And under that regime, which was introduced by statute in 1980, they were not allowed to keep services in-house, for example, reserve them to their direct labour departments, unless the relevant unit of the local authority had won the work in competition with the private sector. Now, that was certainly not required by EEC law. It wasn't even quasi-in-house procurement, but actual in-house procurement. And the compulsory competitive tendering regime was repealed by the Local Government Act of 1999 and replaced with an obligation simply to consider whether the thing should be contracted out. Now, the question to which that gives rise is, could the Treasury reintroduce the compulsory competitive tender regime by statutory instrument under section 2.2 on the basis that they related to the same general subject matter as was covered by the directive? In our submission, they could not. Yet if a common subject matter is a sufficient basis for using 2.2, one's bound to ask, why not? Perhaps the answer is that a common subject matter is not a sufficient basis, but it's the only one that connects it here.
Has anybody ever litigated the scope of 2.2b?
Yes, there have been a number of cases.
Oh, I wish I hadn't asked.
Well, I will do. The Lordship wanted the answer no. The cases on it, and the best known is the Court of Appeal decision in Oakley, which is in the bundles.
Oh, yes.
They deal with specific examples miles away from here, and they are authority for the proposition that the term is wide, and in particular, they're authority for the proposition that the power under section 2.2 embraces implementing optional modes of performance. In other words, if the directive says the United Kingdom can do either A or B or C, there is no obligation to do A, no obligation to do B, and no obligation to do C. My learned friend Mr. Harrow once endeavoured to persuade the Court of Appeal that meant that there was no power to adopt any of A, B, or C, because none of them were an obligation. Your Lordships may not be surprised to learn that that submission was not accepted. My Lord, I should finally deal briefly with the submission which the respondents have based on Regulation 3010. If your Lordships would take volume 2 of the authorities bundle to find that.
Which tab are we looking at again?
We're looking at tab 11.
Tab 11.
And what we need is Regulation 30.
Which is page 50. 49.
I'm grateful.
Sub 10, did you say?
It's subparagraphs 1 and 10, which need to be read together. Subparagraph 1 provides that, subject to another regulation, a contracting authority shall award a public contract on the basis of the offer which is the most economically advantageous from the point of view of the contracting authority, or offers the lowest price. That is the general criterion for the award of contracts after the tendering process has been gone through. Paragraph 10, subparagraph 10 over the page, provides that in this regulation, offer includes a bid by one part of a contracting authority to provide services, to carry out work or works to make goods available to another part of the contracting authority, when the former part is invited by the latter part to compete with offers sought from other persons. So, in summary, this is the regulation which requires public authorities that have gone through the tender process to accept the best offer. Regulation 30 sub 10 provides that for the purpose of Regulation 30, an offer includes a bid by a department of the authority itself if the department has been invited to compete with outside bidders.
Yes.
So this provision recognises that a public authority has no obligation to make its own departments compete with outside bidders, but it says that if they do, then they've got to choose the best bid. Now, one can quite see why, in a case where the authority has decided to put a contract out to competitive tender, the draftsman should have wanted to ensure that the obligation in subparagraph 1 applied to all bidders and not just to those bids which amounted technically to offers to enter into a contract. But since the issue here is whether there was any obligation to hold a competitive tender at all, this provision does not, in our submission, appear to advance the debate one way or the other.
So this is a response rather than I mean, you're not invoking this. You're simply saying it doesn't help the other side.
It doesn't help anyone.
I see.
There's nothing for me in this. I'm simply anticipating a point which is referred to in the judgments below and is prominent in my learned friend's argument.
Right, thank you.
My Lords, issue 2 is whether the TECAL exception applies to contracts of insurance. The argument here is that because a public authority cannot insure with its own department, since there would be no transfer of risk, neither can it invoke the TECAL exception, which is based on an analogy with a case where the authority procures goods or services from its own department. Now, this was not a point which was accepted by either Lord Justice Burnton or the Court of Appeal, although Lord Justice Moorbeek did observe in the Court of Appeal that there was what he called an air of unreality about assimilating an insurance contract to an in-house provision of services. Now, I can deal with this point very shortly. The position of a public authority's own departments only comes into this business as a paradigm of control. The first TECAL condition assumes that the local authority is contracting with a separate legal entity. It then asks whether the authority exercises a degree of control over the separate legal entity, which is similar to that which it exercises over its own departments. So the factual inquiry which the control test invites is simply, how much control does the authority have over the separate legal entity? The Court of Justice in TECAL was not saying that it is a precondition for the application of the TECAL exception that the services should have been capable of being obtained from the authority's own departments. And no other authority says that either. It's simply using it as a paradigm or analogy of control. Now, there are many reasons, of course, why some transactions cannot be carried out by a public authority's own departments. It may need, for instance, a regulatory license. It would in the case of insurance. It may be incapable of being done in a cost-effective way, except by a consortium, which seems to have been the position in Commission in Germany, where before Landkreise certainly could not have used one of their own departments to commission the enormous incineration facility, which they were able to do in conjunction with the city of Hamburg. Now,
what you're asking us to do is to look at the last sentence of paragraph 50 in TECAL and say, does this really meet the point?
Exactly. My lord, that's right.
Are you going to show us the 2009 Act, which now explicitly, so you tell us, I haven't looked, it empowers local authorities to do something akin to this?
I will certainly do so. I can't do that straight away, but I will get it for tomorrow. But that's only concerned with the powers point.
Well, I know, but I mean, is the argument you face here that it's all very well having the power, but actually they couldn't do it anyway?
Well, that is the argument that I face, indeed.
I just want to know if it actually does fly in the face of the necessary implication of the new legislation.
Well, my lord, the new legislation simply says that a local authority's powers are to include a power to set up mutual and participate in mutual insurance arrangements. I will produce the relevant enactment tomorrow. That therefore deals, although not in time to help in this case, with the judicial review, which was at one stage going to be before your lordships. The separate problem, and it is an entirely separate problem, is that it's not enough to have power to do something, which if done would be wrongful under the procurement regulations. And that's the point that my learned friend is making.
But I'm just wondering, does he go as far as say that necessarily this power won't be exercisable?
No.
Okay, well then
I don't think he says that. And I mean, one could attempt to devise a framework under which the power would be exercisable without infringing the local authority, without infringing the procurement regulations. It very much depends which, if any, of my learned friend's arguments your lordships accept. If, for example, your lordships were to accept his argument that collective control is not enough, it's got to be individual control, well, then it's hard to imagine any arrangements which could possibly enable that power to be used. A more modest version of my learned friend's submissions might be consistent with a bit of ingenuity with designing this system.
But he says, as I understand it, the technical exception doesn't apply at all to contracts of insurance.
That's what he says, yes.
But well, then I don't see how you would ever then set up a mutual in this way.
Oh, I see. Well, in that context, that's certainly right. It would be since you necessarily have to do insurance through either a consortium or at the very least a captive subsidiary, Your Lordship is absolutely right on that point, if he is right on this, the power would never be exercisable. I mean, intellectually, that's a possibility that exists. I mean, I can't say that the fact that Parliament has created a power means that a directive which, as transposed into English law, is inconsistent with its actual exercise, can't exist. It's an odd state of affairs, but it is a possibility. I mean, you would, I suppose what my learned friend would say is that you can set up the mutual insurance arrangement, but you'd have to have a competitive tendering exercise every time you placed an insurance contract.
Oh, I see.
But when you start to think what the practicalities of that, it becomes as improbable as the suggestion of tendering for a service contract between Hamburg and the Landkreis in paragraph 46 of Commission in Germany.
Lord, of course it does, because the whole point about mutuals is that they depend on a degree of consistency of business and mutual self-insurance, which becomes very difficult to sustain without a critical mass of authorities involved. So that in practice it seems likely that the obligation to tender for each annual contract would in practice make it impossible to do it. What I find it difficult to say is that the intellectual possibility doesn't exist. It does, but it is a bit of an absurdity.
Thank you.
My Lord, when one looks at the variety of circumstances in which a transaction which is highly cost efficient may not be capable of being done by one local authority's or one public authority's internal departments, may require an element of cooperation, it becomes very difficult to accept that there can be a rule that unless something was capable of being done by a department, it can't be within the Tekal exception. Now, Lord Justice Burnton pointed out, when he was considering this particular argument, that there was in fact no reason why a public authority, forget consortia for a moment, why a public authority with the requisite statutory powers should not enter into an insurance contract with a captive insurer which it wholly controlled, on the basis that the captive would then reinsure the risk into the commercial markets. Now, that, he pointed out, would be a true contract involving a true transfer of risk, and yet it seems to be perfectly unexceptionable under the Tekal principle. Now, what my learned friend observes about this example in his printed case is that the interposition of a captive is simply a way of procuring insurance dressed up as reinsurance from the outside market. Now, with respect, that doesn't seem right, if I've correctly understood the submission. A contract with a captive is a real contract, and it involves a real transfer of risk. It's only on the basis that the captive is in fact bearing the risk transferred that it has a sufficient insurable interest to be able to reinsure. What is more, it is of course very common for the terms of the reinsurance when placed by a captive to differ from the terms of the original that the captive has made with its controller, so that some risk is retained. This has been productive of a great deal of litigation, some of which has reached the House of Lords, where minor differences between contracts that were thought to be back-to-back have resulted, sometimes intentionally, sometimes unintentionally, in captives actually retaining risk. Now, that may be due to bad drafting, but in some cases, of course, it's deliberate. And the classic example where it's deliberate is that it's very common for captives, particularly if they operate, if they insure more than one entity, for example, in a group of companies, to reinsure subject to a significant excess, thereby retaining the risk below the level of the excess. That can be a highly cost-effective way of getting good value of money for your premiums. And this is, in reality, the substance of a mutual insurance arrangement like this one. The reality of the commercial reality of a mutual insurance arrangement like this one is that the local authorities are indirectly insuring each other through a vehicle like LAML up to a given level of value. and the vehicle is then reinsuring out in excess of that level. So it's a true cooperative arrangement between public authorities for mutual reinsurance of themselves up to a particular point. And beyond that, it's a collective arrangement for the procuring of insurance in the market by way of reinsurance. Of course, that means that in procuring reinsurance, a body like LAML, being completely controlled by public authorities, has got itself to comply with the public procurement regulations. Yes. The evidence is that they do for that very reason. Yes. My Lords, issue 3, whether collective control can satisfy the control test in TECAL. This is another relatively short point once the authorities have been looked at and your Lordships have now seen them. It is obviously a critical issue because if each individual member of a consortium has to be able to control the vehicle company on its own, then the thing cannot be done.
Can I see I got the terms of the issue correct? I'm looking at page 4 of the respondent's case,
yes,
where the issues are set out. We dealt with 1 and 2, and 3, you'll remember, is divided into 2 bits. And we were treating 3A as 3 and 3B as 4.
Yes.
And I just want to be quite sure that what you were saying a moment ago actually fits with the way 3A is expressed.
Well, 3A is the relevant
yes.
issue. Whether the contracting authority itself must exercise over the distinct entity in question a control which is similar to that which it exercises over its own departments. That is, it doesn't say or whether it's enough to have collective control, but that's what my learned friend is getting at and makes the point unmistakably in the substantive part of the argument which corresponds to 3A.
And indeed, it's clear if you read 3B.
Yes, indeed. If not, is it sufficient that the contracting authorities and others collectively exercise control? And was that requirement satisfied in this case?
Yes.
I suppose issue 4 comprises issue 3A and the first half of issue 3B.
It does, really. Yes. Yes. Right, thank you very much.
My Lord, clearly one reason why the European Court has consistently rejected the argument that individual control is necessary for each consortium member is that it would effectively, and for no obvious policy reason, make it impossible to have consortium companies except those organised on the basis that the contracting authority happens to have more than 50 or more than 75% of the shares, which is essentially not cooperative at all. But also, the European Court, as your Lordships have seen in the cases that we have been looking at, has made the point more than once, as indeed have successive advocates general, that there is no injury to the policy objective of the procurement directives involved in allowing collective procurement through a collectively controlled vehicle. There's no greater injury in allowing that than there would be in allowing each individual public authority to set up its own subsidiary organisation to do it separately. The fact that they do it collectively does not have any impact on the economic objective which is being sought by the directives. Now, of course, TECAL itself was a consortium case, and although the court didn't decide whether the control test was satisfied on the facts, it must have thought that it could be in principle, or there would have been no point in, there'd be nothing to refer back to the national court. Cabo Termo was a consortium case, although that probably made no difference to the outcome because Cabo Termo owned just under 100% of the shares. The really decisive cases, I would suggest, are Asemfo and Coditel. Now, in Asemfo, of course, the contracting authority only had a 0.25% share, yet the court rejected the argument that the only member of the consortium which satisfied the control test was the Spanish state with its 99%. It did that, as your Lordship saw, for two reasons. One was that as between the 5 authorities who held the shares, it was enough that they should collectively be able to control it, i.e. in the case of the local authorities, that they should be able to control it in conjunction with the Spanish state. And the other was that Tragsa was required by public law to satisfy any order for work that any of the 5 or 4 local authorities gave them. Now, my learned friend says that's the true explanation of the decision. But it seems clear that on its own, the fact that Tragsa had to accept orders from any local authority would not on its own establish control. The fact that you have a legal right to require somebody to render a service to you would not normally be taken to confer upon you control over anything other than the decision to make that service available. It is, however, fair to say that that appears to have been regarded as being at least a reinforcing factor in the ECJ's view that the control test was satisfied. The decisive factor, I would suggest, is the fact that the 5 entities could collectively control 100% of the shares of Tragsa. And that is the proposition for which Asemfo has been cited in subsequent cases, particularly Coditel. Now, my lord, when one comes to Coditel, and we saw that at the beginning of this afternoon, that is clearly a case in which the availability of collective control as a means of satisfying the control test was directly one of the questions asked by the National Court. And the answer to it was that it was sufficient. And in our submission, to say that that case can be distinguished, or that Asemfo can be distinguished on the basis that they were cases decided under the treaty, is to ignore the fact that the courts have repeatedly said that exactly the same test applies in both contexts. Even to the point, as we saw in the Ponte Nossa case, of not bothering to decide whether the directive applies, because it no longer matters. Now, my lords, the argument put forward in the printed case of the respondents is that individual control could not satisfy the control tests under the directives, and that cases like Asemfo and Coditel are distinguishable. And in our submission, that simply cannot be right. More generally, I would suggest that the whole of this principle is driven by a conception of the public interests involved. The supplier, in other words, must not be market-oriented. There must be a degree of control sufficient to establish that the supplier is identified with the public function of the participating authorities. And that is clearly something which is as much satisfied in the case of a collective enterprise as it is in the case of an individual one. And that is perhaps the principal significance of the case of the Commission in Germany, where those points were made in terms.
Yeah, how much is left of this principle once if you go as far as they went in Germany and you abolish this, the middle thing,
Well,
which are being controlled?
It's a very striking case.
Yeah.
I mean, what is so striking about it is that it in fact draws aside the curtain and shows us what this whole jurisprudence is really about. It's really about protecting, ensuring that suppliers who are separate legal entities from public authorities are themselves identified with the public interest and are not commercial enterprises in the sense of having objectives which extend beyond the provision of the enabling the public functions of public authorities to be carried out. That is what it is all about. And that is why it's possible, in a case in which there was zero control, to apply exactly the same principle. My lords, issue 4 is whether the control test was satisfied in the particular case of LAML.
Yes.
That is, of course, very much a matter for a national court to decide, as the Advocate Generals and occasionally the European Court of Justice have wearily repeated in a lot of these cases. The application of the tests to the facts and the verification of the facts is a matter for the national court. Now, LALM, I think the starting point is that LALM was a company limited by guarantee without a share capital. And that, as your lordships will know, is a type of company which is commonly chosen for not-for-profit organisations, charities, regulatory organisations are sometimes incorporated as contracts, as companies limited by guarantee, and indeed mutuals are very commonly organised on that basis. We have included, but I won't cite it, but your lordships may be interested to look at the introductory section of West on companies limited by guarantee, which we've included in flag 5 of the supplementary authorities section. It's really it traces the history and origins. If your lordships look at the first page, a company limited by guarantee is a suitable vehicle for a wide range of activities. Charities which are to have a corporate form must be companies limited by guarantee and must prevent the distribution of profit to their members, as must registered social landlords or housing associations. Companies limited by guarantee are also frequently used for the not-for-profit promotion of education, commerce, art, science or sport, or for promoting the interests of a particular section of society or a particular policy. They may also be used for managing semi-governmental and regulatory functions, including where a former governmental or local authority function has been privatised. And over the page, the company limited by guarantee is not as old as company law. Many educational institutions were incorporated by royal charter or by statute, as were trade associations, which in many cases took the place of medieval guilds. Modern equivalents of these companies could equally well be formed as companies limited by guarantee. Then it deals with the position of trades unions, and there is a section later in this chapter that makes the point that it is common to incorporate mutuals as companies limited by guarantee, so as to avoid the consequences of actually conferring shares on members.
Yes. You will have seen that in paragraph 104 of his case, Mr. Howell picks you up on this point, because he says you say, or you assert rather, that LMAL was wholly owned by its members.
Well, he's right about that.
And he says, well, that's contradictory to what's in the statement of facts and issues and the point you've just been making.
He's right about that, in that technically the members of a company limited by guarantee do not own the company, but they do have a contingent ownership of its assets, in the sense that upon a winding up of a company limited by guarantee, the assets, if there are any, will be distributed among the members. Now, my lords, for the purposes of the control test, the salient points about LAML are summarised in our printed case with references to the relevant parts of the core volume. They are, I would suggest, the salient points are these, and I can deal with it. I won't deal with it in precisely the order in which it appears in my printed case. But first of all, there is the fact that LAML has no private capital and no private membership. Under its articles, only London local authorities are eligible for membership. And if your lordships would take the core volume, just to make good these points as I come to them, page 197, paragraph 6 of the memorandum, so it's article 6 of the articles, forgive me. Any London authority is eligible for membership of the mutual. Now, there are two classes of members. Lord, I see the time. Would your lordships perhaps find it?
I think we can carry on just a couple of moments.
There are two classes of members.
Yes.
Members, tout court, and participating members. And they are defined at page 182 of the core volume in the memorandum. Member means any London authority that has subscribed to the Memorandum and Articles of Association, and there were 10 of those. Participating member means a member who receives indemnity from the fund, who contracts with it, in other words. And there were 7 of those in the relevant years. The participating members are the members who are insured, and the participating members are the only members who have rights under the constitution of the company to participate in its general meetings and so on. So that the first point about LAML is the absence of private capital, private membership, or indeed any shareholding at all. Secondly, LAML is a not-for-profit company, which is a significant factor in considering whether it is an enterprise of a commercial character. If your lordships would look at paragraph 6 of the memorandum of LAML, the income and property of the mutual shall be applied solely towards the promotion of its objects as set forth in this memorandum of association, and no portion thereof shall be paid or transferred directly or indirectly by way of dividend, bonus or otherwise, by way of profit to participating members of the mutual, otherwise than in accordance with the rules. So nobody gets any money out of this. Thirdly, the objects of the company, as defined in its memorandum, are to provide mutual insurance to those of its members who become participating members by contracting with it, and to their affiliates. And I will explain to your lordships in a moment what affiliates are. But if your lordships would turn to page 180 in the core volume, perhaps one should start with 182, just below subparagraph 19, about halfway down the page. You will see that the objects of the mutual, as specified in paragraphs little Roman 1 to little Roman 2 above.
Page 182.
This is 182, yes. The objects, as specified in 1 and 2 above, shall be construed as the main objects of the mutual, and the powers conferred on the mutual by any of 3 to 19 shall be restricted by reference to or inference from the terms of the main objects of the mutual. So that the main objects are the, so to speak, the real objects, and the rest are ancillary, available as ancillary powers only. And 1 and 2 are one is to receive premiums from participating members or affiliates, and to indemnify through a mutual fund the liabilities, losses or expenses incurred by participating members or affiliates in accordance with the rules. And object 2 is to grant or effect with participating members or affiliates for the purpose of mutual insurance such classes of insurance as the mutual may from time to time be authorised to carry on under the Insurance Companies Act 1982 or any act amending or extending the same, and to enter into or to arrange insurance or reinsurance contracts on behalf of any participating member or participating members or affiliates as deemed necessary from time to time, and to negotiate directly or indirectly with the insurance market cover for any risk on behalf of any participating member or participating members or affiliates. So those are the real objectives. Among the subsidiary objectives, there are some, for example, little Roman 10 or little Roman 14, which would empower the company to enter into partnership with other entities or to acquire other businesses. But these are only exercisable for the purposes identified in 1 and 2.
Well, would it be convenient to stop?
My Lord, absolutely.
And resume at 10:30 tomorrow morning?
My Lord, yes. I would expect to finish probably about an hour or so into tomorrow.
Thank you very much.